Costco suing the federal government. The retail giant's asking for a full refund if the U.S. Supreme Court strikes down President Trump's tariffs. The lawsuit is similar to other suits filed by companies challenging the legality of Trump's tariffs. The Supreme Court's expected to announce its ruling early next year. ABC's Elizabeth Schulze is here with more on all that. So, Elizabeth, what's Costco hoping to gain from this lawsuit?
Diane, what Costco wants is money that it's paying for those tariffs. The wholesale retailer says that it wants a full refund for the tariffs that it's paid under this act that's been imposed by President Trump. The International Emergency Economic Powers Act, IEPA, has been what it's called. And, of course, we heard arguments earlier this fall in the Supreme Court under whether President Trump has the authority legally to impose tariffs under that act. So what Costco is saying is it wants to get money back once that decision is made, which we, as you say, do expect.
Okay, so you need to understand what just happened at the Supreme Court, because this is one of the most significant legal defeats that Trump has faced during his entire presidency. And it shows us exactly how his aggressive power grab is backfiring on him in ways that are going to fundamentally cripple his ability to control the federal government and his ability to implement his regulatory agenda across the entire executive branch. President Trump has been pushing aggressively to fire independent agency heads, people like FTC Commissioner Rebecca Slaughter and other officials at agencies like the Consumer Product Safety Commission and the National Labor Relations Board, because Trump believes that he should have the power to fire anyone in the federal government who works under him and remove them from office whenever he wants to, without any legal restrictions whatsoever. Trump has been operating under what's called the unitary executive theory, which is the idea that the president should have nearly unlimited power to control every single agency and every single official in the executive branch, and that no one in the government should be able to stand up to the president or challenge his authority in any meaningful way. But before we go any further, real quick, let's be honest. You can't really trust mainstream media anymore. That's why we built Pump Politics, to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us. Be part of the community that actually cares about the truth. All right, let's get back to the video.
Early next year. But keep in mind, Costco is one of several retailers that has done this. Retailers are saying that the president does not have the authority to impose these tariffs, that it's Congress's job to put them in the first place. We don't know in this filing, Diana, exactly how much Costco has paid in tariffs, but you would imagine it's a pretty significant amount if they're putting this lawsuit out there. We do know that the government has collected at least $90 billion in tariff revenues under this act so far this year. And that's money that it would need to go back to companies, essentially try to figure out how to get that money back to companies that have paid them. The money is still being collected at this point, and Costco did say in this filing that is expected to make a payment to Customs and Border Protection later this month.
And Elizabeth, how is the Trump administration responding to this?
You know, what the Trump administration is saying, Diane, is that this shows how necessary these tariffs are. They point to the revenue that's coming in from tariffs, and they say this is proof that it's working to try to.
But when Trump started actually trying to fire these independent agency commissioners, the Supreme Court stepped in and essentially told him that he cannot do this, and that nearly a century of legal precedent is standing in his way and protecting these agencies from direct presidential removal power. The Supreme Court has now fast-tracked a ruling on Trump's firing power that is being described by legal experts and by justices themselves as an absolute nightmare for Trump's entire agenda going forward. The emergency docket of the Supreme Court has been moving with incredible speed to address this issue. And we have already seen some really troubling signs for Trump in the form of dissents from liberal justices that are blasting the idea that the president should have unrestricted power to fire independent agency heads without any congressional oversight or any legal limitations on his authority. Justice Elena Kagan wrote a scathing dissent that basically said that if the Supreme Court rules in Trump's favor on this issue, it is going to give Trump full control over every major federal agency in the country: the Federal Reserve, the Securities and Exchange Commission, the National Labor Relations Board, the Consumer Financial Protection Bureau, all of these agencies that are supposed to have some independence from direct presidential control. Kagan's dissent makes the point that ruling in Trump's favor would fundamentally transform the nature of the federal government and would concentrate unprecedented power in the hands of the president at the expense of Congress and at the expense of the independence that these agencies are supposed to maintain by law. What makes this situation so significant and so dangerous for Trump is that the Supreme Court is operating on what is called the shadow docket, which means they are moving very quickly and making decisions without the normal briefing process that usually happens in Supreme Court cases. Normally, when a case gets to the Supreme Court, both sides file lengthy briefs where they lay out their legal arguments in extensive detail. Then there are oral arguments where the lawyers present their cases to the justices and answer questions from the bench. Then the justices deliberate and eventually issue a ruling that explains their reasoning. But with the shadow docket, the Supreme Court is fast-tracking this process and making quick decisions about emergency matters without going through all of that normal procedure and without the usual safeguards that protect against hasty or poorly considered rulings. This is exactly the kind of thing that Justice Kagan is criticizing in her dissent. She is saying that the Supreme Court is abusing the shadow docket to rush through a ruling that could fundamentally transform presidential power without properly briefing the issue and without taking the time to think through the massive implications of what they are ruling on and how it will affect the entire structure of federal government. The Supreme Court has granted what is called an emergency stay, which means that Trump is being allowed to go ahead and fire these independent agency heads while the case is still being litigated and while the Supreme Court is deciding what the final ruling is going to be in this case. The 6-3 split on the stay, with 6 conservative justices voting to allow Trump to proceed with the firings and 3 liberal justices dissenting, tells us that this is going to be a closely decided case with serious implications for the future of presidential power and the structure of the federal government. The fact that it is split 6-3 rather than 5-4 tells us something important about the dynamics of the conservative majority on the court. The case is set for oral arguments in December of 2025, which means we are going to hear the arguments from both sides very soon, and then the Supreme Court is going to issue a ruling that could fundamentally change the balance of power between the president and the independent agencies. What really gets to me about this entire situation is that Trump is fighting against a legal precedent that has been in place since 1935. The case is called Humphrey's Executor, and in that case, the Supreme Court ruled that Congress has the power to limit the president's ability to fire certain independent agency heads without cause. The whole idea behind this precedent is that some agencies need to have independence from direct presidential control in order to function properly and in order to serve the public interest rather than serving the political interests of whoever happens to be president at any given time. Let us really dig into what is happening here with the Supreme Court and what evidence and legal arguments are being presented, because there is a lot of complexity to this case, and understanding the full scope of what is at stake is crucial to understanding where Trump's presidency is headed. The Federal Reserve is a perfect example of an agency that needs independence from direct presidential control. If the president could just fire the Federal Reserve chair whenever they wanted to, because the Fed made a monetary policy decision that the president did not like, then you would have the president interfering constantly in monetary policy for political reasons. You would have the president pressuring the Fed to keep interest rates low right before an election so that the economy looks good, even if that might cause inflation or other economic problems down the road. The whole point of giving the Fed independence is to allow them to make decisions based on sound economic policy rather than on what is politically convenient for the president. But Trump is essentially arguing that this precedent from 1935 is wrong and that the president should have the power to fire anyone in the executive branch for any reason or no reason at all. Trump and his lawyers have been arguing that the Constitution gives the president inherent power to control all executive officials and that Congress cannot take away the president's power to fire people who work for him. If the Supreme Court agrees with Trump and overrules Humphrey's executor, it would be a massive expansion of presidential power, and it would fundamentally transform how the federal government operates and how independent agencies function. The implications of this ruling for Trump's entire regulatory agenda are absolutely huge, because so much of what Trump wants to do depends on being able to control these independent agencies and bend them to his political will. Trump has repeatedly indicated that he wants to fire the head of the Federal Reserve because he is unhappy with the Fed's monetary policy decisions. Trump has indicated that he wants to fire commissioners at the SEC and the NLRB because he thinks those agencies are too aggressive in protecting workers and consumers and are not pro-business enough. Trump has indicated that he wants to take over the Consumer Financial Protection Bureau and turn it into an agency that serves the interests of financial institutions rather than protecting consumers from predatory lending and other abusive practices. If Trump wins this case at the Supreme Court and can fire these agency heads at will, he will have unprecedented power to reshape the entire regulatory state and to eliminate regulations that he thinks are bad for business. He will be able to turn independent agencies into tools of his political agenda rather than institutions that serve the public interest. The problem for Trump is that the lower courts have already blocked his at-will removals of these agency heads, which means that judges have already looked at this issue and decided that Trump does not have the power to fire these people whenever he wants to. Trump is now trying to get the Supreme Court to overturn what these lower courts have ruled and to basically tell the lower courts that they were wrong about the law. The Supreme Court's intervention by granting an emergency stay is buying Trump some time and allowing him to proceed with the firings while the case is being litigated, but it also signals that the Supreme Court thinks there might be serious legal issues with what Trump is trying to do. If the Supreme Court was completely confident that Trump had the power to fire these agency heads, they probably would not have granted an emergency stay in the first place because there would be no emergency to stay. The Solicitor General of the United States, who is the lawyer who represents the federal government before the Supreme Court, is personally arguing this case for Trump. The Solicitor General's name is Sauer, and he has been making the argument that the president should have broad power to fire independent agency heads, but the fact that the case is split 6-3 on the emergency stay suggests that Sauer's arguments are not completely convincing even to the conservative justices, or at least that some of the liberal justices think there are serious problems with allowing Trump to fire these agency heads. Justice Kagan's dissent, in particular, is really scathing about the abuse of the shadow docket and about the idea that the court would rush to judgment on an issue this important without properly briefing it and thinking it through completely. There are also parallel cases that are piling up and adding to Trump's legal problems. One particularly significant case involves Costco, which has filed a lawsuit challenging Trump's use of the International Emergency Economic Powers Act to impose tariffs on imports. If the Supreme Court rules that Trump does not have the authority to use the IEEPA to impose tariffs, then Trump could potentially be forced to refund hundreds of billions of dollars to companies that have paid tariffs that were imposed without proper legal authority. This is another case where Trump is pushing the boundaries of executive power and arguing that he has authorities that many legal experts believe he does not actually have. The combination of this tariff case and the firing powers case creates a perfect storm of legal challenges to Trump's assertions of executive authority. What is particularly interesting is that all of these cases are exposing the weakness of Trump's legal defenses and his reliance on aggressive assertions of presidential power that may not hold up under scrutiny. Trump has been operating on the assumption that conservative judges and justices would simply defer to his assertions of executive power and would not seriously question whether he actually has the legal authority to do the things he is trying to do. But the Supreme Court's willingness to grant emergency stays and to require full briefing on these issues suggests that even some conservative justices are concerned about Trump's broad assertions of executive power and about whether he is operating within the bounds of his constitutional authority. Here is what this all really means for Trump and for his ability to govern and for his entire regulatory agenda going forward. Trump came into his second term with big plans to reshape the regulatory state and to eliminate regulations that he thinks are bad for business and bad for the economy. But he is discovering that his power is much more limited than he thought it was, and that there are real legal obstacles standing in his way that cannot just be overcome by asserting that the president has the power to do whatever he wants. The Supreme Court is not automatically deferring to Trump's assertions of executive power the way that he apparently expected them to. And even the conservative justices seem concerned about the breadth of Trump's claims about what the president can do. If the Supreme Court rules against Trump on the firing powers issue, it will be a massive defeat for him, and it will mean that he cannot simply fire independent agency heads and replace them with loyalists who will do whatever he tells them to do. Trump will still have to respect the independence of agencies like the Federal Reserve and the SEC and the NLRB, which means he cannot bend these agencies completely to his political will. This would be a huge blow to Trump's regulatory agenda because so much of what he wanted to accomplish depends on having direct control over these agencies. If he cannot fire the heads of these agencies and replace them with people loyal to him, then he is stuck working with the existing leadership of these agencies. And many of these people are not sympathetic to Trump's agenda and will not cooperate with his efforts to eliminate regulations and reshape the regulatory state. The implications for Trump's broader legal situation are also significant because this case is part of a larger pattern of Trump losing legal battles and having his assertions of power rejected by the courts. Trump has lost multiple cases in federal court. He has been rejected by judges on various legal claims. He has had his immunity defense rejected. He has had his attorney-client privilege claims pierced by prosecutors. And now he is facing the possibility that the Supreme Court will reject his claim that he has the power to fire independent agency heads at will. Each one of these legal losses erodes Trump's position and makes it harder for him to govern effectively and to implement his agenda. The timing of this case is also problematic for Trump because it is coming at a moment when his presidency is already under tremendous strain from multiple directions. The DOJ lawyers have quit en masse, which means Trump does not have the government's legal resources to help him defend his policies and his actions. Republican members of Congress are turning on him, which means he cannot rely on Congress to protect him or to defend his actions. His administration is falling apart with scandals and leaks and internal dysfunction. His press secretary is melting down in briefings. And now the Supreme Court is potentially going to rule against him on this major assertion of executive power. This is the kind of cascading series of defeats that creates a sense of complete collapse and total loss of control. What is particularly damaging about this case is that it goes to the heart of Trump's entire governing philosophy and his understanding of how presidential power works. Trump believes that the president should have essentially unlimited power to control the federal government and to do whatever the president thinks is in the national interest. But the Constitution and the laws that Congress has passed place real limits on presidential power, and the courts are supposed to enforce those limits. If the Supreme Court rules that Trump cannot fire independent agency heads at will, it will be a repudiation of Trump's core understanding of how presidential power works and how the president should be able to govern. The Supreme Court's potential ruling could also create momentum for other legal challenges to Trump's assertions of executive power. If the court rules that Trump cannot unilaterally fire independent agency heads, then that ruling could also apply to other assertions of executive power that Trump is making. Trump could face additional defeats on the tariff cases and on other cases where he is asserting that he has the power to do things that many legal experts believe Congress has actually limited or prohibited. This could create a cascade of legal defeats that makes it increasingly difficult for Trump to implement his agenda and increasingly difficult for him to govern effectively. What we are seeing here is the collision between Trump's understanding of how presidential power should work and the actual constitutional and legal limits on presidential power. Trump came into his second term apparently believing that he would have nearly unlimited power to do whatever he wanted as president. But he is discovering that the courts are willing to step in and enforce the limits that the Constitution and Congress have placed on presidential power. This is good news for the separation of powers and for the rule of law, but it is very bad news for Trump and for his ability to govern and implement his regulatory agenda. The Supreme Court's ruling on this case could fundamentally reshape Trump's presidency and his ability to accomplish his goals going forward.